Hello and welcome to the e-Pathshala course on competition law. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Today we are going to discuss a module on intellectual property law and its interface with competition law and policy. In this brief outline, we are going to discuss the role of competition law and policy in IP and the contested goals of IP law and competition law and policy. Differentiation as an underlying principle of intellectual property law versus dynamic efficiency that is sought to be achieved by competition law and policy. The contested goals of efficiency vis-a-vis public good, because efficiency is demanded by competition law. At the same time, intellectual property conceptually in an economic sense is a public good with non-rival and non-excludable characteristics. We will also discuss TRIPS and international flexibilities around the interaction between intellectual property law and policy, whether TRIPS tries and achieves a kind of fair sense of balance or whether it does not lay down any kind of principles regarding the same. We will also discuss competition law and policy thresholds within IP law vis-a-vis how competition law thresholds are designed in the competition law sense. We will discuss what remedies follow due to abusive conduct of intellectual property holders within patent law. At the same time, the abusive conduct, the remedies for abusive conduct in competition law. We will discuss section 3, 4, 5 and 6 of competition law with reference to restrictive agreements, restrictive IP agreements, abuse of dominance and its relationship with IP, and IP issues involving foreclosure and combinations. We will have some specific focus on pharmaceutical IP and how pharmaceutical IP is looked from the perspective of competition law and policy in cases involving abuse of intellectual property. We will also discuss standards essential patents and how competition law policy is sought to defer to intellectual property. At the same time, if exclusionary conduct or exclusionary relief is sought by intellectual property holders in case of SAPs, how does competition policy try to resolve them? At the same time, we will also see how unfair and discriminatory pricing and non-pricing conditions may attract violations of provisions of competition law. We will finally provide a brief summary of the issues that are discussed during the course of the discussion. Let's start with a basic discussion on how markets work. Do free markets actually work has been one of the central problems of understanding how intellectual property and competition policy interact with each other. Now, Adam Smith, one of the famous propounders of the free market theory, in his classic book The Wealth of Nations, an inquiry into the nature and causes of wealth of nations, published in 1776, said, "People of the same trade seldom meet together even for merriment and diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices." Now, what did he say when he meant conspiracy against the public in contrivance to raise prices is classically one of the problems that you would encounter in intellectual property. Now, by way of the structure of intellectual property, it grants kind of monopoly rights. However, it does not mean that patents are monopolies in a sense that the market power that is conveyed by the patent law has to be tested by virtue of how the product gets accepted in the market, and at the same time the availability of closer substitutes. However, theoretically, the presumption of free market theory is that the invisible hand is going to work to try and strike a balance as to how markets will efficiently provide better outcomes. In relation to intellectual property, one of the important questions has been how different are the goals of competition law and policy vis-a-vis economic efficiency and consumer welfare. Now, if you look into one of the important reasons why competition law seeks to achieve what it does is to come out with an economically efficient market system. However, at the same time, sometimes certain kinds of efficiency which lead to both productive, static and dynamic efficiencies can and may lead to consumer disregard and a lack of consumer welfare. So, at times the decisions in competition law may hinge on consumer welfare. At the same time, it is important to understand that competition law and policy does not deal with harm to individual consumers, but harm to competition. However, these contested goals of competition law and policy, both in terms of economic efficiency and consumer welfare, are not conclusively resolved in favor of either. Similarly, in relation to intellectual property law and policy, one of the important reasons and economic reasons why intellectual property policy law grants certain rights to create a kind of market power is due to the underlying principle of differentiation. Now, if there are products that are similar, market will stop innovating further, and because of free riding, no one will have the incentive to produce new products and processes. So that's the reason why, if there is a differentiating capacity in a product or a process, intellectual property law immediately kicks in, and that's why differentiation is the primary goal of intellectual property law and policy. Similarly, in relation to efficiency versus public good, now competition law seeks to achieve dynamic efficiency. However, at the same time, knowledge is a public good. Now, when I say dynamic efficiency is different from static efficiency and productive efficiency, which believes that in relation to productive efficiency, that resources are put into best possible use. At the same time, static efficiency creates price related competition. So, one of the important things that we need to discuss in relation to competition law and its relationship with innovation market is the concept of dynamic efficiency. I will explain this by virtue of an example of a lemonade. Now, the concept of innovation market simply goes that if you have static competition in prices, then ultimately prices will come down to a level where competitors cannot compete in future. So they will compete in innovation by improving their products. So in this example of a lemonade, if there are two vendors selling lemonades, then from a competition perspective, I as a competitor would try and reduce the prices to gain more consumers and produce more output. But however, if the other competitor starts lowering the prices to an extent where it becomes unprofitable for me to further reduce the prices, then I will think of improving the lemonade by adding maybe a straw or a lemon inside and selling it with some additional spices. So that would actually result in product differentiation, which is the key that drives innovation. So in this sense, the lemonade example clearly explains why dynamic efficiency in intellectual property can lead to certain benefits that competition law envisages in terms of market growth and opportunities. Now, in relation to dynamic efficiency, although there is no price related competition, dynamic efficiency leads to creation of innovation markets and furthers the objective of intellectual property law and competition law, which is to help creation of new products and processes which in a situation without intellectual property would be difficult to achieve. However, intellectual property is a public good, and we realize this because if you look into the economic characteristics of public good in terms of non-rivalry and non-excludability, they apply to information as such. By non-rivalry, it would mean that if you have an apple and I have an apple, and if we start consuming the apple, we can only leave as much as we have left. However, if knowledge is consumed by 10 people simultaneously, it would be non-rivalrous in consumption in the sense that the knowledge as a resource will not be depleted. Similarly, in relation to excludability, if I hand over either a land or a chattel to you, it means that I am excluded from using it. At the same time, once I deliver knowledge or information to you, I cannot dispossess you from using that piece of knowledge. So that's one of the important characteristics of public good, which differentiates it from other kinds of goods, and information and knowledge is essentially a public good which the intellectual property system tries to protect. Now, if you look into the TRIPS agreement leaves a lot of leeway for countries to adopt measures that are consistent with the agreement. In fact, Article 8 states very clearly that you can take certain measures that are necessary to protect your sectors of vital importance, protect public health. At the same time, Article 8.2 allows you to take certain measures that allow you to prevent abuse of intellectual property rights. Now, however, both these articles, Article 8.1 and 8.2, must be taken in a way where you can prove that they are necessary and at the same time they are consistent with the TRIPS agreement. At the same time, it's important to note that Article 8 allows you to take non-violation measures which are currently allowed in the TRIPS agreement due to the existence of a moratorium. Article 40 of the TRIPS agreement has to say quite a bit on the intellectual property and its interaction with competition policy. However, the principles that are enshrined in Article 40 are committee principles and they are not binding on member states as such, except that they are good faith obligations. There is no principle created by virtue of Article 40. However, one can argue that Article 40 interpretation can lead to a conclusion that countries may necessarily have to use the rule of reason instead of structural kind of arguments for examining this relationship between intellectual property and competition policy, but this is highly contested. In the context of discussion on intellectual property and its relationship with competition policy, it's very important to understand that although competition policy thresholds are enshrined in the Competition Act, however, at the same time there are certain ex ante competition policy thresholds uniquely designed in patent law. Let's take an example of Section 3D of the Indian Patents Act. Now, Section 3D, by virtue of the Novartis decision, clearly means that the law differentiates between certain types of efficacy, and Section 3D demands enhanced therapeutic efficacy. Now, if you try and understand why standards of obviousness or novelty, including standards like Section 3D, have been incorporated into the patent law, is to create a certain level of competitiveness in terms of who gets to patent inventions. So, if the threshold was quite low, then certain materials which would have been otherwise in the public domain and free for competition would have been usurped by the patent applicants. However, by virtue of higher thresholds like Section 3D, the competition policy threshold within patent law works to enhance competition. Similarly, within patent law, after the grant of the patent, you have important provisions that deal with abuses relating to patents. In this, it is important to realize that Section 84, Section 91, Section 92 and Section 92A of the Patents Act clearly provide opportunities for third parties to apply for compulsory licenses. There are licenses of related rights. There are opportunities where by a special notification of the government can initiate a compulsory licensing process. At the same time, a compulsory license can be purely granted for the purposes of export in what are also called as Doha style licenses. Similarly, Section 140 of the Patents Act in India has elaborate provisions which deals with avoidance of restrictive conditions, in which certain types of licensing conditions, if they are present in the licenses, are clearly declared to be void. Hence, we can understand from these two circumstances that patent law has policy levers which are designed in a way to maintain competition, and hence both in terms of pre-grant and post-grant there are exclusive provisions which are designed in the Patents Act. Now, we must realize that the analysis of remedies under patent law vis-a-vis competition law for abuse of monopoly can be entirely different. So, if you look into the recent decision involving compulsory license of Bayer's drug Nexavar, it was granted on three important grounds. One, that the reasonable requirements in relation to the patented invention were not being met because Bayer was supplying to less than 2% of the patient population. Two, that the prices of the drug were extremely high. Bayer was selling the drug at 2,80,000 per patient per month. And three, that Bayer did not territorially work the invention. However, if you look into all three grounds on which the compulsory license were granted, it might be argued that they relate to certain kind of abuses that the patent holders engage into because they are under an obligation not to do certain things. However, these obligations that are created and the abuses that are mentioned in Section 84 in relation to patent law are based entirely on a structural presumption largely relying on public interest. But if you look into competition law, even if there is denial of access to certain essential facility, or if there are restrictive trade agreements, or if the combinations lead to foreclosure and competition, they are essentially based on evaluation of market power and market effect. competition law does not make any kind of structural presumption in relation to either public interest or in relation to other kind of factors that are non-economic in nature. Similarly, if you look into the remedies involving violations of intellectual property and competition law, since IP is a bundle of rights, the right to exclude or transfer is inherent in intellectual property, and property law actually allows you to exercise those freedoms within the bounds of the monopoly that is conveyed by patent law. However, at times there can be patent misuse, and patent misuse is a principle that has arisen out of courts in the United States and elsewhere, where by virtue of acting with beyond the temporal and physical scope of the patent holder is engaging in a kind of abusive conduct, which is distinct from a competition policy concern where abuse of market power leads to violation of competition law and policy. However, over a period of time, the patent misuse jurisprudence and the competition law and policy jurisprudence in relation to intellectual property have significantly merged. Now, if you look into both these patent misuse, patent law and policy, and competition law and policy and their remedies, then we will realize that ultimately it turns up to liability rules, where courts act as interveners and kind of intervene and try and set a solution by way of a compulsory license. However, in case of competition law and policy, an additional measure of divestiture can be included, wherein the companies can be broken, and it will have nothing to do with compulsory license as an effective remedy as such. This is also quite possible within the framework of competition law. Coming to the Indian Competition Act 2002, there are certain exceptional sections which create kind of questions or deals with the interface relating to intellectual property law and policy. Section 3.5 primarily deals with those kinds of licensing practices which are unreasonable in nature. However, there is lack of any effective guidance in relation to what do you mean by unreasonable kind of licensing practices, because a patent holder is allowed to take all reasonable measures within the scope of patent law to protect his intellectual property. The Act Section 3.5 makes an exception only with reference to unreasonable conditions. We will look into a bit of this spare parts decision, wherein the Competition Commission of India has come out with an order which clearly kind of lays down the objectives of competition law in relation to its interaction with intellectual property. Section 3.5 and its exemption of reasonable conditions in relation to defending your property rights was argued as one of the defenses by the opposite party, that is the spare parts manufacturers. In this case, the manufacturers of automobile and spare parts denied access to spare parts to various vendors in open markets, and hence the question was whether such denial and refusal to license spare parts and selling of spare parts would violate competition law. The defense taken by the opposite party, that is the spare parts vendors, was that since it involved intellectual property involving patents, designs and copyrights, hence it would be important to allow the exercise of such rights within the scope of Section 3.5, and that Section 3.5 would exclude any kind of action against the exercise of valid intellectual property rights. In its first conclusion, the CCI came to a kind of conclusiveness that most of the intellectual property rights primarily relating to patents and designs were not registered in India, and if they are not registered in India, it wouldn't matter if they raise a claim relating to patents, because patents are anyway territorial. At the same time, CCI also laid down clearly that even questions relating to validity of intellectual property rights that are granted in India, CCI would not have appropriate jurisdiction to look into the issues of validity, because that has to be done by other agencies allowing the registrations of various intellectual property rights. However, it was claimed by the opposite party that in relation to copyright, since copyright protection is automatic, specific registration in India would not require, and conversion of a three-dimensional or two-dimensional artistic work into a three-dimensional spare part would ultimately infringe the intellectual property rights. Now here CCI took a kind of a reasoning that here the case did not actually involve in reproduction of artistic works by way of coming out with specific spare parts. It only related to the end products, the physical products that involved the spare parts as such, and by refusing to sell those kind of physical products which although have embedded intellectual property, such kind of refusal to sell those products independent of the car manufacturers would amount to a kind of violation of section 3. If you look into the questions relating to unilateral price restraint, one of the important questions in the context of section 4 which talks about unfair or indiscriminate terms of pricing, it's interesting to consider here is whether refusal to license intellectual property violates the provisions of the Act. Now an IPR owner enjoys a kind of statutory monopoly endowed upon him under the prevalent under relevant IP Act. If the IPR owner refuses to license his intellectual property, it could amount to violations if section 4(2)(bi), that is limiting production of goods or provision of services or market, if that is violated, or section 4(2)(b)(2), that is restricting the technical or scientific development relating to goods or services to the prejudice of consumers, if that is violated, and section 4(2)(c), that is denial of market access. Although there are not many cases yet in India on the issue of compulsory licenses by CCI, it is likely that CCI may be called upon to consider the grant of compulsory licenses in certain situations. It may be important to understand that a compulsory license under the Patents Act can be granted only after the expiry of 3 years for the various grounds that we have understood in the previous slide. However, competition law can grant and competition commission can grant a compulsory licenses almost immediately after the grant of a patent. We have an interesting situation in relation to copyright in HT Media versus Supercassettes Limited. Here the allegation was that HT license was invoked. Here HT Media sued T-Series at the Competition Commission, saying that T-Series, which has 80 to 90% of all film music in India, was not following the 2% royalty rate set by the Copyright Board, and was instead charging the old rates of 660 rupees per needle hour, which is approximately 4 to 5 times higher than the 2% royalty rate that it was supposed to charge. Now given that T-Series has over 80 to 90% of music, radio stations had no option but to take license at the rates demanded by T-Series. At the same time, this kind of a situation led to hold up by the company, and hence the defendant HT Media approached the CCI, and CCI passed a prima facie order relating to abuse of dominance against T-Series. T-Series agreed by this order, challenged the jurisdiction of CCI before the High Court, and here the High Court held that CCI is well within its boundary to look into the instant factual metrics involving violation of section 4. It was held that once the CCI comes to a conclusion which is adverse to the interest of T-Series, the CCI shall allow a week's time to T-Series to approach the appropriate forum for grant of relief. So the matter is still pending in CCI in relation to its finality. However, the important issue there was the jurisdiction issue, whether CCI has jurisdiction to hear and rule on this matter, and whether section 31 of the Copyright Act 1957 states that Copyright Board is empowered to issue compulsory licenses. What would be the appropriate contours of that particular act? The issue is whether only Copyright Board can examine, or whether in terms of the reasonableness of the license, or whether CCI can also take its role of examining the kind of license fees that T-Series charges. So in such cases, both authorities may examine the reasonableness of the license in relation to fixing a particular royalty rate or remuneration. However, it is important to understand that since both the authorities have concurrent jurisdiction, how will such jurisdictional overlap be resolved in the long run? Another case that relates to issue of cases involving abuse of intellectual property is Bull Machine versus JCB Limited. In this case, JCB through an ex parte stay had prevented Bull Machines from launching its construction equipment called Smart Bull in an exhibition in Bangalore. It was said that JCB withdrew the interlocutory application from the Honorable High Court of Delhi, and it was filed to harass the defendant, that is Mrs. Bull Machines. The CCI passed a prima facie order under 26(1) of the Act directing the DG to investigate the matter of JCB's abuse. Now, JCB challenged the CCI's jurisdiction before the Honorable Court. The High Court's observation were very pertinent. It said that once an interlocutory order application has been disposed of, the CCI does not have the jurisdiction to interfere. It was also observed that it was a consent order, and instead of approaching the CCI, Mrs. Bull Machines would have filed a suit of restitution if it felt aggrieved. The High Court allowed the investigation to go, but barred the DCJ or CCI from passing any order or report. Now, if you look into section 5 and 6 of the Act, that deals with foreclosure of competition. One of the important questions in relation to competition policy and its interaction with IP law is that when companies merge, take over, or kind of create combinations, what would be its ultimate impact on innovation market and technology markets? Now, we haven't had any clear-cut case on this particular issue. However, it is important to understand that in the context of different kind of industries, the implications regarding competition due to combinations will vary. It is important to understand that under section 5 and 6 there are no structural kind of restrictions on combinations. However, there are certain thresholds which needs to be followed, and if by virtue of those thresholds the competition policy reviews and finds kind of anticipated impact on innovation market from a exercise of market power perspective, then they can definitely intervene. Let's finally look into two sectors which are key to Indian industry. One is the pharmaceutical sector, and the other one would be the ICT sector. In the pharmaceutical sector, it is important to question how intellectual property and its relationship with competition law will play out in relation to patents that are sought by pharmaceutical companies vis-a-vis generic companies which want to have more and more access to these products so they can provide competitive pricing. Now, one of the conditions in which competition law and policy operates is that it has to define what is the product universe and the relevant market. The relevant market in relation to a specific good would be that where by virtue of increase in prices or certain acts of unilateral acts of the IP holder, there would be sufficient consumers who would shift to another substitutable product. Now, in case of intellectual property, there are hardly closer substitute products, so it becomes very important to understand what would be the exact type of relevant market. Now, in such cases, refusal to license or anti-competitive or conditional licensing can lead to certain kind of consequences. However, it is also important that it's not just intellectual property holders that may be involved in relation to abuse of IP, but by virtue of reverse payments and settlements, certain kinds of anti-competitive restrictions may have important consequences for public policy. Now, if you look into recent reports that are appearing in the media, the CCI has initiated probe into pharmaceutical industry's patent drug settlements with generic manufacturers, saying that such patent settlements could potentially violate abuse of dominance clause in the section 4 of the Act, and which would mean that buyout of generic drug manufacturers would in relation to their capacity to enter the market would ensure that the drug which is circulated in the market would be delayed. While there is a possibility that such payments may be in order to ensure that generic companies stays out of the market, the key issue is of identifying the payments made and the reason for such payment, and if there are valid reasons why payments were made, then it would be difficult for CCI to intervene in such matters, and CCI may want to exercise some amount of caution in relation to reverse payments and settlements. This is unique in India because unlike the Hatch-Waxman Act of the United States, wherein a 180-day exclusivity is created in behalf of the first generic entrant, in India we do not have any kind of such incentives to challenge the validity of the patents and subsequently grant any generic kind of market exclusivity. In India, after the expiry of the patent, any company is free to enter the market irrespective of being the first or second. They have market exclusivity in relation to the generic products. Now, finally, in relation to section 5 and 6, combinations, mergers and acquisitions, and competition law and policy, it is important to understand how such acquisitions may change the generic company strategies in terms of its ability to challenge patents, in terms of its ability to obtain compulsory licenses. Both these are kind of industrial policy questions rather than those that have immediate impact on competition law. However, in consideration of these mergers and acquisitions, if of a generic company, it would be important to find out if the long-term strategies of these companies are going to change. Moving on to another interesting area, standardization patents, which are largely discussed in the context of information and communication technologies. We have a couple of important decisions involving Micromax and Intex. In this case, there are two cases pending before the CCI where Ericsson has been alleged to have demanded unfair, discriminatory and exorbitant royalty for its standardization patents. Standardization patents primarily mean that by virtue of a setting of standards, patent holders get their standard inventions embedded into those standards through various standard setting organizations. They commit to something called as fair, reasonable and non-discriminatory terms of license, and further, after the setting of the standards, when a sufficient number of manufacturers switch over to manufacturing those products, they hold up patents against such manufacturers and then start demanding unfair royalties. And that's one of the reasons why the CCI would want to intervene in such matters. The CCI has been made aware of the fact that these issues have been agitated before the Delhi High Court in terms of relevant provisions of the Patents Act. Now, CCI has passed orders directing the Director General to undertake investigation. The CCI has also noted that it has obligations under its jurisdiction to examine issues pertaining to violations of competition law, and that the pendency of any kind of civil litigation at the High Courts should not take away the jurisdiction of the CCI. Now, apart from the jurisdictional issues that is usually alleged in such cases, it would be important to understand that seeking exclusionary relief may amount to violations of competition policy if it is coupled by a situation where there is a willing licensee to accommodate FRAND and to comply with FRAND. Only in cases where there is an unwilling licensee, CCI's jurisdiction in relation to the question of there has been a violation may not be entertained. Otherwise, wherever there is a situation of a FRAND license, and if an exclusionary relief is sought, European Competition Commission, for example, has held that it may amount to violation of competition policy by virtue of abuse of dominance. In summary, we realize that the role of competition law in intellectual property is quite helpful in understanding the economic dynamics of both the systems are not in tension but are aligned towards the same goals. We have also seen that although differentiation is the underlying principle of intellectual property, there is inherent dynamic efficiency that is central to competition policy, and both those try and achieve almost the similar objectives. TRIPS has immense flexibilities. It does not have to say much on what should be the exact nature of interaction between IP law and policy, and hence leaves a lot of leeway and space for policy maneuvering for developing countries like India. Competition law policy within the IP thresholds are quite popular in the Indian context, and one of the examples that we have seen in this lecture is section 3D of the Competition Act. And in case of ex post or post grant flexibilities that are there in the patent law that deals with certain types of price and non-price related abuses within the framework of patent law, also has a lot to enhance competition in the markets. However, at the same time, we see that competition law can also intervene at certain levels for violations of Section 3, Section 4 and Section 5 and 6 dealing with restrictive practices or restrictive agreements, abuse of dominance and foreclosure by way of combinations and mergers and acquisitions. Similarly, remedies within IP law can flow via a compulsory license, and at the same time remedies in competition law can lead to divestiture or even a compulsory license. However, both the reasons for granting a compulsory license within IP law and the reasons for grant of a compulsory license within competition law can be distinct, one involving the assessment of public interest and the other involving the questions of economic efficiency and market power. Indian Competition Act Section 3, 4 and 6, although limited in terms of actual guidance, but certain cases that we have seen in the discussion can throw some light on how the policy of competition law and its interaction with intellectual property is going to evolve in the days to come. Finally, we saw that intellectual property and competition policy in relation to pharmaceuticals has a special role, especially in a country like India, where the generic companies are having a lot of say in terms of providing access to medicines, and hence it is important to consider what sort of practices that IP holders play in markets can harm generic competition. Similarly, in case of standards essential patents, we have seen from the discussions that seeking exclusionary relief can at times be declared as violative of competition law because it amounts to abuse of dominance. Similarly, whenever the IP holder creates certain unfair licensing conditions by not disclosing the terms of license and by providing discriminatory terms of license, then it can also lead to potential violations of competition law and policy. With this, we conclude this short module on intellectual property rights and competition policy. Thank you one and all.